Thank you. Good afternoon, ladies and gentlemen. Good afternoon, citizens of Trinidad and Tobago. I have asked for this media conference in order to address a very serious development which I can understand the public of Trinidad and Tobago is understandably very concerned about. I'm speaking about the judgment which was delivered earlier this week on Monday by a master of the High Court, in which the former accused in the Vidya Naipaul criminal trial, who had been acquitted, have been awarded substantial sums of money. Substantial sums of money following on the failure of the state to defend the case which they had brought before the High Court for malicious prosecution when they were brought before Mr. Justice Holdip for the trial of the murder and kidnapping of the late Mrs. Vidya Naipaul. Let me say immediately, ladies and gentlemen, citizens of Trinidad and Tobago, that the purpose of this media conference is so that, as Attorney General and on behalf of the government of Trinidad and Tobago, I acknowledge that this is a grievous development and a development which, in my view, needs to be addressed frontally, and for which there must be full accountability and transparency. Some of you may know that I was out of the country. I left Trinidad and Tobago on Sunday morning to attend a meeting of the Caribbean Financial Action Task Force in Nassau, the Bahamas. And in my absence, my colleague, the Honorable Minister Stuart Young, Minister of Energy and Energy Industries, acted for me as Attorney General. I was actually in the conference on Monday morning, which started at 7:30 a.m., 31st of January, in Nassau, when I received by WhatsApp a copy of this judgment. I know I received it later. The conference started at 7:30. I received the judgment from Mr. Young. I excused myself from the conference. I had a brief conversation with him. I agreed with him that an immediate investigation should be launched. I agreed with him that he should issue a media statement that day to say that on my return to Trinidad and Tobago, which was last night at about 7 p.m., I would stand here as I do today to account to the citizens for this very grievous development. And I do so now. I don't need to recap, but I will very briefly touch on the fact that everybody would know of the very tragic and painful process of the trial of Mrs. Vidya Naipaul. She was tried before her murderers, her alleged murderers, were tried before Mr. Justice Holdip, as he then was. He is now in the Court of Appeal, Justice of Appeal Holdip, and they were acquitted. But I will say at once that that case before Mr. Justice Holdip went through an entire preliminary inquiry. The defendants were committed to trial at the assizes, and there was, on that basis, the committal to trial, a prima facie case, meaning there were reasonable grounds to support the charges. At the High Court, before Justice Holdip, the matter survived a no-case submission on the basis that there was a case to answer by the accused, and went to the jury, which is an indication that the police had a sufficient legal basis to proffer the charges. In point of fact, two of the accused in that case went all the way to the Court of Appeal, and I'm just pulling up the papers on that, because as a result of the very hard work of my colleague, Mr. Young, who ordered an immediate investigation, I've had the benefit of looking at a judgment which was issued by the Court of Appeal in Civil Appeal number 272 of 2012 between Joey Lewis and the Attorney General and Akil Kiran Golster and the Attorney General, two of the accused in the Vidya Naipaul murder trial. They went to the Court of Appeal on a challenge that they had no case to answer in the Vidya Naipaul matter. The case was heard before Mr. Justice Peter Jamadar, as he just then was, Justice of Appeal, Mr. Gregory Smith, Justice of Appeal, and Mrs. Maureen Rajnorth Lee, Justice of Appeal, as she then was. Mr. Jamadar and Mrs. Maureen Rajnorth Lee are now judges of the Caribbean Court of Justice. They delivered a judgment on the 31st of July, 2013. And after hearing all of the arguments of these two co-accused in the Vidya Naipaul matter, the court at paragraph 26 concluded, in the circumstances, we conclude that there was reasonable and probable cause to charge Joey Lewis and Akil Golster with the offenses of murder, kidnapping, and kidnapping for ransom. Accordingly, the appeals are dismissed. So two of the co-accused in the Vidya Naipaul have already had, Naipaul murder trial, have already had a pronouncement that there was reasonable cause for them to be charged as they were, as were all of the other co-accused. Mr. Young ordered an immediate investigation, and I will say here and now that I have agreed with and I associate myself with the fact that there is to be a full investigation of this matter, because the public is owed an explanation for what has occurred here. As best as I've been able to in the limited time since we got notice of this judgment on the 31st of January, Monday of this week, today is the 1st of February, Wednesday, we have been able to unearth some facts. So I'm able to give you a brief summary of some of the facts which we've been able to unearth. A relevant question in this case will, of course, have to do with the timeline. But before we get to the timeline, let me tell you that what the case which went before the Master of the High Court, which has resulted in an award of damages to these co-accused who were acquitted, what that case involved, and the judgment which was produced, as you all know, on Monday, is that they have been awarded damages. Beg your pardon. Something just fell. Do I pick it up and put it back? Thank you. They have been awarded damages in the sum of close to $20 million for their having obtained a default judgment against the state of Trinidad and Tobago, represented by the Attorney General, on the basis that the default judgment produced a decree by which the High Court of Trinidad and Tobago is adjudged to have prosecuted these gentlemen with no reasonable cause, and therefore to have prosecuted them maliciously. My very limited investigation to date has advised that the claim form and statement of case filed by these gentlemen was filed on the 29th of May, 2020, and it was served on the Solicitor General's office on the 22nd of June, 2020. An officer of that department has signed for acceptance of service on the 22nd of June 2020. On the 23rd of June 2020, the record shows further that a file was opened for the matter and that the file was sent to the Solicitor General for assignment. Thereafter, the file disappeared. This is the file. That file there is what disappeared on the 23rd of June 2020. What is on the table there, as a result of the efforts of Mr. Young yesterday, we have retrieved from the registry of the High Court, because Mr. Young got onto the registry and said, these are all documents filed with the High Court. Can we see them? Because until yesterday, when we got those papers, the Office of the Attorney General, the Secretariat of the Attorney General, and I will come to that, had never seen those documents. The file disappeared on the 23rd of June 2020. Having been signed for as received on the 22nd of June 2020. It seems incredulous, and it demands an explanation. What we've been able to piece together, and I use the term piece together deliberately because this warrants a full investigation, and all appropriate agencies will be brought to bear on this investigation. What we have been able to piece together is thereafter, on the 5th of August, a notice of application for default judgment in that matter was further served on the Office of the Solicitor General. It was received on the 12th of November, 2020. So just to pause for a moment to assist the public to understand, when you get served with a statement of case, and that's the statement of case in which these gentlemen are claiming that they were maliciously prosecuted, the defendant has a certain time under the rules of court to put in a defense, to say, no, you do not have a case for false or malicious prosecution because you had a full trial before the High Court. You made a no-case submission which was dismissed. There was a preliminary inquiry which ruled that there was a prima facie case made out against you, and your colleagues have been to the Court of Appeal and had their case dismissed because there were reasonable grounds to have charged you in the first case. In other words, there was a slam dunk defense available to the state of Trinidad and Tobago on that case, but for the fact that the file disappeared. Let me make it very clear. This is a very early stage. I do not want anything that I say to appear to be an indictment of anyone. I am addressing the understandable outrage and concern that members of the public must experience. And the fact of the matter is, and I acknowledge there are very competent professional persons who man the office of the Solicitor General and the Chief State Solicitor's departments, which are departments of the Attorney General's office, where those documents were served. I am not impugning anybody's professionalism. This matter deserves a full investigation, and until the facts of that investigation are discovered and fleshed out, I would not want anyone to suggest that by anything that I'm saying today, I am attributing responsibility to any one particular person or more than one. But the fact remains that an explanation is demanded for a $20 million outrage that has been visited on the citizens of this country. I will not permit myself at this stage, as a result of due process, to utter what I think has occurred in this case, but it is sinister. I have asked for, and I will be commissioning the briefing of external counsel to advise me on the next few steps that must be taken in this matter. I will also be asking for the advice of that external counsel to advise me on the necessary forensic skills that will have to be brought to bear in the investigation which has been launched. And I want to assure the citizenry and the public that that investigation must be accomplished within the shortest possible time. In the meantime, I will also be asking for advice, having between last night, I arrived back in the country at 6:30. I got home at about 7:45, 8, and I started reading that document online because it was on my computer. I had got it from Minister Young while I was in conference in the Bahamas. There are aspects of what is pleaded in that case by the attorneys who represented the accused, led by Mr. Anand Ramlogan, that in my view provide a basis for an appeal. But I am not going to advise myself. The Attorney General is the defendant in that matter, and a lawyer who has himself for a client has a fool for a lawyer. So I'm not going to advise myself. I will be briefing this out to external counsel, but it strikes me, having read some of those papers this morning, that there may yet be a basis on which the actual default judgment, which started the ball rolling to have the state adjudged guilty on a case which was a slam dunk successful defense, that actual judgment, even at this late stage, may yet be capable of being appealed. As well, I will be asking for advice on an appeal to set aside the judgment of $20 million, which was being pronounced by the master. Let me make it quite clear as well that in nothing that I say do I in the least impugn the professionalism of any of the judges who have sat on this matter. People like to call press conferences and point fingers. I don't do that. And therefore, nothing that I say suggests that there wasn't evidence before the master by which she arrived at the decision that she did, because she had an undefended case before her. No one stood to say, think twice about what you are being asked to do by Mr. Ramlogan and his team. Ladies and gentlemen, I fully understand that there is a lot of questions. There are a lot of questions which the public is entitled to ask. I will just say a few more things before I open the floor for questions. The office of the Chief State Solicitor is a legal office in its own right. It is a fully fledged department. The office of the Solicitor General is a legal office in its own right. They are headed by chief legal officers. They form part of the Office and Ministry of Legal Affairs, Attorney General and Legal Affairs. They are responsible, the Solicitor General's office and the Chief State Solicitor's office are responsible for managing litigation for and on behalf of the state, both in prosecution of civil claims and defense. Back in, I forget the actual date, it's gazetted, my predecessor, Honorable Al-Rawi, created the Office of the Attorney General's Legal Secretariat, which was created for the purpose of helping to coordinate the activities of the Chief State Solicitor and Solicitor General's Department. The Legal Secretariat of the Office of the Attorney General does not carry the principal responsibility for the prosecution or defense of claims brought by or against the state. What it seeks to do is to keep things coordinated as it is informed by those two offices, Chief State Solicitor, Solicitor General, and therefore to keep the Attorney General advised. I was provided by that Secretariat when I returned here last night by email with a memorandum which was written under the hand of the former Attorney General, Minister Al-Rawi, dated the 23rd of January 2018. And that memorandum was captioned, "Procedures to be followed in civil litigation matters." And it states, it's addressed to the Solicitor General, it's addressed to the Chief State Solicitor, it is addressed to the law officers of the Civil Law Department. That is to say, all of the professional persons who are engaged in representing, advising, and defending the state in civil law. And it states, from Minister Al-Rawi, then Attorney General, due to the number of matters in which my instructions on approval are not being sought, it has become necessary for this memorandum to be issued. Please be advised of the following procedures. Retention of external counsel and/or instructing attorneys. 1. Instructions are required from the Attorney General to retain counsel and/or instructing attorneys at every stage of the litigation process. Pre-action, High Court, Court of Appeal, conditional and final leave applications to the Privy Council and the Privy Council related matters. 2. Instructions are not required where external attorneys are previously retained in a High Court matter and there is a procedural appeal as a result of a decision in the High Court matter. However, approval is needed to file a procedural appeal. Court actions. Approval is required from the Attorney General to issue any pre-action protocol letters, file a High Court action, file a counterclaim, file an appeal, appeal to the Privy Council. It continues. Settlement of civil litigation matters. Approval is required from the Attorney General to settle all civil litigation matters in which the Attorney General is named as a defendant or represents a named defendant, inclusive of pre-action matters. Approval is required for the settlement of damages and/or interest and/or costs. The instructions and approvals required above can be requested via email and/or by sending the file to the Attorney General. Instructing attorney should not dispatch any documents, including settlement procedures, unless he or she is satisfied that the instructions and/or approvals were obtained from the Attorney General. Kindly ensure that this memorandum is circulated to all law officers, as a failure to follow the above procedures may result in disciplinary proceedings. What this memorandum reinforced January 31st, 2020, sorry, I called the wrong date, January 23rd, 2018. I was looking at an earlier memorandum to me from the Director of Legal. January 23rd, 2018, what this memorandum reinforces is that when a matter like that arrives at the office of the Solicitor General, particularly where it is a complex or very important matter, the Attorney General's office must be advised and approval sought and obtained. That file was never brought to the attention of the Attorney General's Secretariat. It was received at the Solicitor General's Department, as I've indicated on the timeline outlined, on one day, and the following day it went missing. And the first that the Attorney General's Secretariat learned of the existence of this claim was when the judgment was delivered on Monday of this week, the 31st of January. Let me emphasize, citizens of Trinidad and Tobago, that by what I have just said, I am not seeking to pass the buck. I accept that the buck stops here. As Attorney General, I am responsible under the Constitution for the management and conduct of civil litigation by and against the state of Trinidad and Tobago. What has occurred, just to repeat, is grievous, and it must never be allowed to happen again. And I give to the public of Trinidad and Tobago the full assurance that as soon as I have had the results of the investigation, which I have ordered, I will be accounting further to the citizenry in full and transparent manner. Thank you very much. I'm pleased to take your questions.
AG Derek Atcham from Guardian Media here. The case was filed on the 29th of May 2020. It was served on you, and you said that based on the preliminary results of the investigation, the file disappeared shortly after.
No, it was served on the Solicitor General. It wasn't served on the Attorney General's office.
Well, but the Solicitor General Department falls under the Ministry of the Attorney General. Yeah, so it was served on you guys, and on that department, and it was subsequently misplaced. The application for the default judgment, you said, was made in...
I haven't said the file was misplaced. I said the file disappeared.
Okay, so it disappeared.
I'm very careful about the language that I use.
Okay.
The file disappeared. I might go as far as to say, subject to the investigation, that it was caused to be disappeared. But I won't say that just yet.
Okay. So the application was made for the default judgment in August. According to Master Alexander's judgment, appearance was entered on behalf of the state, but a defense was not filed. So my question is that, you know, having clearly somebody was assigned to the case for appearance to be entered, so if the file was no longer in the building, or wherever it might have been, couldn't they not have applied to the court or approached the other side for a copy of the file?
Can I answer that question by saying that you asked one of the questions that the investigator will inquire into?
Okay. And then, having applied for the default judgment, it was only granted by Justice Joan Charles, leading to the assessment before the master in January the following year. So, you know, within that time frame, was it also possible for the attorney on record to apply for an extension to file the defense?
May I say again, Mr. Achong, in the shortest possible time, I hope after the investigation which I have ordered commences and is completed, that I will be in a position to answer those questions. I do not wish to jump to conclusions. There are too many questions that need to be answered, for which, as I stand before you at the moment, I do not have the answers to. But certainly, those are legitimate questions which have to be asked, and there will have to be accountability.
Okay. I want to move on to, but I don't know if anybody want to answer the topic. I want to.
Jens Levin, Newsday, AG. You said the file was rediscovered sometime either today or yesterday after the investigation was launched by the acting AG.
May I correct you? I didn't say the file was rediscovered, Mr. Levin. I said that having received notice of the fact of a judgment dated the 31st of January being handed down, providing for an assessment against the state of 20 million, the acting Attorney General got in touch with the court registry, said to the court registry, this is a case filed with your registry. Can the Attorney General's office, on an urgent basis, be provided with soft copies of what is filed with the court registry. The court registry sent that to Mr. Young, and that is what you have in front of me. The file was not, by what I have said, rediscovered. It was asked for, and it was provided by the Judiciary Registry as a result of a request by Minister Young, Acting Attorney General, on the 31st of January, 2023.
The question I was getting at is who or how many people would have had control of that file?
That is a burning question which I hope will be answered by the investigation that I have asked should commence and proceed urgently. One of the questions that I have asked is, what is the process at the Solicitor General's Department and the Chief State Solicitor's Department from the moment a matter is served by which that matter is tracked, kept control of, and accounted for at every stage? That's a question that I have asked, I will be asking the investigator to get careful answers to.
And any possible criminal charges could stem from this?
I will not attempt to answer that question until the investigation is complete and I have had proper advice.
AG, last year in November, while speaking in Senate, you revealed that you were having discussions with the TTPS and the Ministry of National Security in terms of, probably amending the State Liability and Proceedings Act to make errant police officers in legitimate malicious prosecution cases liable for the damages that the states have to pay, which is quite significant, we know, over the years. Does a scenario like this, beg the question whether that should be extended to more public officers, just not the police, the defense force, the customs and excise division? I mean, I know the investigation is at a preliminary stage, but,
Permit me, Mr. Levin, to answer that question in two... Mr. Achong, I'm sorry, beg your pardon. Apologize to Mr. Levin, first of all, and to you, secondly. Permit me to answer that question in two parts. What I said in the Senate at the time was a statement to the fact of I having started a discussion without any approval as yet from Cabinet on a very preliminary basis with relevant officers and persons. And I would go on record now to say that that is still without Cabinet approval and still at a very preliminary stage, and it would be premature of me to extend that preliminary observation to very different circumstances, such as what we are speaking about today. So I'd prefer not to engage that question. Thank you.
Attorney General, are there no systems to alert the Attorney General or his secretariat that an appearance has been entered into by his office?
Well, I think that the systems are referred to by not least of all the memorandum that I just read, dated the 23rd of January 2018, which had been sent out by the then Attorney General. And he said, due to the number of matters in which my instructions and approval are not being sought. So to answer your question, Ms. Tate, I think it would be to say there should be systems. Until this outrage, we have been operating on the basis that the systems have been working, not perfectly, but working, but clearly something has gone very wrong.
I was told that there was a system in place put in by Ramesh Lawrence Maharaj, I think, where there would be monthly meetings between the Attorney General and the Solicitor General to keep him abreast of important matters filed against the state. Is that system still in place?
Far be it for me to speak for or on behalf of Mr. Ramesh Lawrence Maharaj, nor would I attempt to speak on behalf of former Attorney General. Since I have taken office, I have met on at least 8 or 10 occasions with the Solicitor General. We have a very good relationship. We continue to discuss a number of matters that are under her portfolio and a number of areas in which the Department of the Solicitor General needs support and assistance. So to the extent that you ask if there is a system, I'm not sure I would refer to what I have had the personal experience of as a system, but I am in regular contact with the Solicitor General in the interest of been apprised of what is happening in that department and working towards helping them to improve their working circumstances, conditions, and the quality of service that they provide to the people of Trinidad and Tobago.
But in view of what has happened, would you agree that our mechanism for regular and well, I guess for mandatory almost contact on these issues, that is necessary so that we prevent a recurrence of this kind of mistake?
Let me answer that in two ways, Ms. Tate. One is certainly what has happened has pointed to the fact that a system needs to be put in place to prevent the recurrence of what has happened. It must never happen again. What that system will be by way of improving on the communication system that I have with the Solicitor General at the moment, what that system will be by way of improving on the system that the Solicitor General has in her department, by which junior members of her staff report to her on an ongoing basis. We will see what comes out of this investigation, and certainly there will have to be a redoubled effort to improve the systems so that these grievous lapses do not recur.
Who is the Solicitor General? Who was it? One person involved from 2020 to now in this matter, or is it that there were several appointments or actions? Yes. But I mean, yes.
Mr. Achong, you detected my reservation. I don't like to call names, and again, as I've said at the beginning, I'm not pointing fingers anywhere. The Solicitor General in office in 2020, now retired, is Ms. Carol Hernandez, and the current acting Solicitor General is Ms. Carleen Senath.
Given the fact that at least one of the persons is retired, would that impact the investigations, because you may not have the capacity to question if the person is no longer within the public service?
No, I wouldn't think so at all. Since I have been in office, I have been in regular contact with Ms. Hernandez. To her credit, she has been on pre-retirement leave and has continued to make herself available to do a lot of work for the Solicitor General's department, even whilst on pre-retirement leave. I have high regard for her, and I know that she will cooperate with any investigation if the investigators decide they wish to speak with her. But I'm not going to preempt what the investigation is going to do.
I know you're reluctant to assign culpability, but does this not point to a fundamental weakness in the public service that falls under you, that something like this can happen? I'm not talking about whether it's Mr. A or Mr. B, but that a matter like this, a case like this where, for several reasons, should have alerted somebody to the implications. One, it involved a very high-profile case, Vindra Nightfall, that, I mean, the country was focused on this case. The state hired 3 senior counsel for this case. A lot of money was spent in legal fees. Secondly, it involved, the lawyer was Anand Ramlogan, a former attorney general, who has been, beaten the state at many cases in the court. And 3, it involved multiple defendants, 9 people. So, I mean, how could the public, anybody in the public service who had receipt of this, who appeared in court, who was involved in any way, not understand that this case was going to have massive implications if the state did not properly defend it?
Well, I'll answer that question with 2 short comments, Ms. Tate. One is, as I've said before, I don't want to preempt the investigation. And the second comment I will make is to say to you, yes, it is correct. Mr. Anand Ramlogan is involved in this case.
And what about public service? What does it say about the state of the public service?
I'm not preempting that part of the question. Let's wait to see what the investigator says. The investigator will be asked to come up with recommendations, and those recommendations, I have no doubt, will touch upon the very question that you've asked.
Has the investigator been appointed, and can you reveal who is the investigator?
No, the investigator has not been appointed. I learned about this matter in the middle of a conference on Monday. I arrived in the country last night. I have in mind a couple persons, but I haven't yet spoken with all the persons that I have in mind.
But it will be done by somebody externally from the ministry?
Oh, yes, certainly externally of the ministry, and I intend to brief external counsel as well to advise. Shortest possible time. I wouldn't want to preempt myself on that, but certainly it deserves very urgent attention.
Attorney General Jules Brown, TV6 News. I'm just wondering, has this matter caused you to have any conversations with any relevant officials in your ministry to look at any other matters, civil matters, where there could be the potential for this kind of thing to ensure that that does not happen with any other matters presently before the court against the state?
Well, let me answer your question this way, Mr. Brown. My conference in the Bahamas started at 7:30 on Monday morning. It finished at 8:30 Monday evening. I left my hotel at 6 a.m. yesterday morning. I arrived in Trinidad and Tobago at 7:45 yesterday evening, and I have been in meetings since 9 o'clock this morning. I have had conversations with the current Solicitor General acting. I have had conversations with the current Chief State Solicitor on the telephone and by email, and the questions that you have asked are questions that certainly will be explored, but I'm not able to tell you the details of that, because I'm in the early stages of the corrective action and the attention to concerns that needs to be addressed in this matter.
You read a memo that would have been written, as you said, by your predecessor in office, Mr. Alwari. Have you had any direct conversation with him or plan to as part of the investigation into this matter?
I've had 2 brief conversations with him since this morning, waking up at 5 a.m. I went to him since I came out of the...
You've been saying, ideally, there are certain things that should reach the office of the Attorney General. I'm wondering, for example, let's say soon after you would have taken your oath of office, ideally should something like this have been brought to your attention, or matters of this nature, immediately as soon as you were sworn in or thereafter?
In a perfect world, all important matters, and this would be one, ought to be brought to my attention. That is part of the ongoing procedure that the Secretariat of the Attorney General's chambers seeks to ensure takes place in the coordination with other departments of the Attorney General's office. In a perfect world, we would expect that to happen on a 100% basis. There is room for error, but I would expect that the errors would never again be as monumental as this one.
Does your office, I mean, I know you said that you're going to seek advice from counsel on whether you should appeal. Would the state be applying for a stay of just Master Alexander's decision, because a stay wasn't granted 20 days? You know, sometimes that is usually attached to at the end of a judgment, so that, you know, these men wouldn't be able to make the claims to the payments before the investigation is completed and those determinations are made. And the state will have to reclaim it if they eventually succeed.
Very good question, Mr. Chong. Yes, in the advice that I will be seeking from external counsel, if I receive advice that there are good grounds to appeal, certainly one of the things that will be considered is for the court to be asked for a stay. The mere filing of an appeal does not by itself grant a stay. You then have to apply to the court for a stay. But I think in all of the circumstances, given the personalities involved, and by that I mean persons who don't necessarily have property that can secure the recovery of those sums to the tune of $20 million, and given the sum involved, we would certainly, once we are advised that there are good grounds to appeal, ask the Court of Appeal to stay the payment of the sums until the determination of such appeal as may be advised.
As far as you are aware, any of the Solicitor Generals themselves were made aware of this case? Not the office, but the Solicitor General.
I have spoken with Ms. Senath, as I mentioned, that is the acting Solicitor General, and I have not personally spoken with Ms. Hernandez, but Ms. Senath tells me she has spoken with Ms. Hernandez. So the then Solicitor General in 2020 and the current Solicitor General have both been spoken with. Myself with Ms. Senath, and I'm told by Ms. Senath she spoke with Ms. Hernandez.
And they both had no knowledge of this?
We have received responses. We are processing those. Those will be part of the investigation.
You mentioned the memorandum earlier on. Failure to adhere to the memorandum would result in what, if any, punishment?
Well, what the memorandum says is that failure to adhere will result in disciplinary proceedings. And there is a schedule in the Legal Profession Act for disciplinary proceedings. There is also a scheme within the public service for disciplinary proceedings. I will await the full investigation. I will await advice and recommendations from external counsel with respect to that.
Is there a digital system that can keep the Attorney General abreast of cases filed against the state? Is it not possible to have that kind of system?
There is a digital system in place so that in the normal course, if the file had not disappeared on the day after it arrived and someone appears not to have kept track of it at all, the Attorney General's office, the Secretariat, ought to have been informed digitally that this case is on the system, and attention thereafter directed to whether, given the importance of the case, external counsel should be briefed to defend the case and to take charge of it. There is a system. The system was not activated because one day after that large file was physically handed in to the Office of the Attorney General, it disappeared. It physically failed to exist and still physically fails to exist. It only exists now in what is before you because in the pandemic, and 2020 was within the pandemic, the High Court Registry resorted to ensuring that all court filings were done soft copy and hard copy. So luckily for us, when Minister Young called the registry, he was able to retrieve from the registry the soft copies, which I've had printed because I'm old-fashioned. I still like to read paper and lick my finger and turn the pages and stick Post-its on the paper.
AG, I know the investigation hasn't officially started, but from what you have gathered, is there any inkling of political involvement in the disappearance of this file?
I would not want to comment on that at all. Nothing is being ruled out in the investigation, let me tell you that, but I would not want to comment on that.
AG, if the file had disappeared, how could the attorneys on record who entered the appearance did not file a defense, how were they able to participate in the assessment of damages and challenge the claims that were being made by this group of men? Because in the claim, it was actually 3.1 million each they were actually seeking. So they managed to convince the court to reduce it somewhat through their submissions. So, I mean, somebody had to have the file, whether it was in the right bookcase or if it was e-filed, someone in the ministry must have had that file.
What I understand, and that is subject to the investigation, being more careful than my 24-hour on a plane, off a plane inquiry has enabled me to do, is that the court office emailed a copy of the notice of application for the default judgment and a copy of the notice of application of the hearing of the assessment of damages to the Solicitor General's Department. So at that stage, in 2022, in respect of a file that had disappeared in 2020, the file re-entered the SG system. That's the little I understand. And these are things that I consider to be red flags that should have alerted somebody to the existence of what was taking place, and we will want answers to that.
Yeah, because that is very confusing, what you've just said, that there were further instances of notification?
The court office, because the court office has the email addresses of the attorneys. So when an order is made, the court office would, in the normal course, send notice to the parties.
So
An order would be sent to the parties by the court office.
So what you're telling us is that there were at least 3 or 4 opportunities for the
Ms.
state.
I would like to be definitive in my answers to you. It would be premature
Well, more
of me
than
to.
one, several
It would be
opportunities.
premature of me to answer it beyond what I have said. I hope you all won't mind, but I think that I have answered as many questions as I possibly can, so that without attempting to limit this press conference, what I consider to be an important press conference for accountability, and I say the buck stops with me, and I will take responsibility for this, but before I can, in definitive terms, I would want to understand what has happened by the outcome of an investigation which I have launched.
Adrian, we have one more question, slightly unrelated to the case, but I think you'll be able to answer.
So we saw over the weekend there was some reporting on the Commission of Inquiry into the highway project, and there is a disclosure that $4.3 million was allocated for outstanding payments to the commissioners, but we have not seen a sitting of that Commission of Inquiry yet. Can you tell us what's happening with that?
Can I come back to that question and answer it? I will. I promise you I will. But before I answer that question, there are 2 other matters that I just wanted to talk to, because I think it's important as we discuss the bad news that we should also discuss the good news. So one of the 2 other matters that I wanted to discuss, and you would have seen the media statement that I issued, my office issued earlier this week, and that is the landmark decision of the Court of Appeal in which the state has won a very serious case. It is a case involving the Civil Asset Recovery Management and Unexplained Wealth Act. And that decision was handed down by Justices of Appeal Mendonca, Wilson, and Rajkumar yesterday. And what that case involved in the government's efforts to track the profits of criminality, very significantly, the legislation in place allows the state to go after the proceeds of crime even without having proof beyond a reasonable doubt in relation to the person who committed the crime, because it has introduced a very novel principle of law of the soiled fruits of the poison tree. So if you acquire property and that property is in excess of your accountable wealth, the state can go after that property and seize it as being acquired by illicit means. That legislation is a very significant piece of legislation, and it has allowed retroactive effect to financial circumstances and transactions that took place before the passage of the Act in 2019. And yesterday, the Court of Appeal upheld that decision in very significant terms. So I would like, as we dwell on the unfortunate situation in the Vidya Naipaul case, to also acknowledge some very significant landmark steps that this government has taken towards managing crime and the illicit proceeds of crime. The other thing that I just wanted to give an update on is the conference that I attended in Nassau. That conference has to do with the work of the Caribbean Financial Action Task Force, and it has to do with money laundering, again, illicit money laundering, counterterrorism activity, and what we spent an entire day doing. Council of Ministers, so the Attorney General of the Cayman Islands, St. Kitts, who was our host, Barbados, Turks and Caicos Islands, Trinidad and Tobago. We spent the entire day working on equipping Trinidad and Tobago and other Commonwealth Caribbean territories to enhancing our capacity to pass all the checkpoints set by the International Financial Action Task Force, so that we can continue to conduct business at internationally accredited standards that will have us not on any grey list or blacklist as we move forward with the economic recovery of Trinidad and Tobago. So those are 2 significant developments that I thought I should just put on the record that have occurred in the last 36 hours. returning to your question on the Commission of Inquiry, I have some knowledge of the Commission of Inquiry because before I accepted the appointment as Attorney General, I was actually the lead counsel on that Commission of Inquiry. I have been replaced by Mr. Gilbert Peterson. I know that the Commission of Inquiry, from my most recent conversations with Mr. Peterson, is getting ready to start. They've drafted a number of documents which are to go out shortly, and from what I understand, they will be starting within a very short period of time. But I digress to address the two matters, so if you don't mind asking the very specific question that you asked so that I can attempt to answer it, I'd be happy to. I think it had to do with a sum of money.
Right. There was a sum of $4.3 million allocated in May of 2022 for outstanding fees for the commissioners and the secretariat. So the question being raised in the public domain is if the commission has not yet started, we still don't have a date. I mean, you're saying we're going to see it starting soon. That is not giving us a definitive date. What was that money used for?
Let me put it this way. I couldn't speak to the specific sum that you have called out in terms of what it was used for. I know that while I was lead counsel to the commission, I did a lot of preparatory work. I charged some fees. I was paid. One of my juniors, I had two juniors, I believe. I think they charged fees. I believe they were paid. I don't know if that amounts to that sum. And I don't know, since Mr. Peterson's team has come on board, whether they have billed out for any fees. Those fees would go to the office of the Prime Minister. So I can't answer specifically what those sums are to be held accountable to. I don't deny the fact that fees have been paid out. I know I got some fees for some of the work that I had done.
Attorney General, I have one final question. You said external counsel would be engaged in this matter. Will the police be engaged in this initial stage as well in the investigation?
I won't discount that, but I will first wait for advice. And I'm going to ask for the advice on an urgent basis. From whom? I haven't yet decided from whom. It will be a counsel external of the Attorney General's chambers. It will be, I would prefer, a Trinidad and Tobago lawyer as opposed to going external to Trinidad and Tobago. I'm speaking to a couple at the moment, and I have to see who is available. And it will be a senior counsel.
What would you say to the public, which tends to be very cynical with respect to investigations of things that happened that were not done properly and money wasted and the taxpayers, because the taxpayers are the ones at the end of this that have been really treated very badly. We have to put out this money, and it's more than 20 million because it's retroactive. Interest is retroactive, so it's going to be more. So what do you say to the cynical public that is tired of these kinds of things? Nothing happens. Nobody's held accountable. You know, people just are allowed to fade into the sunset and nothing comes out of it.
I'll say three things, Ms. Tate. One is I completely understand your ire and the ire of the public. What you have said is one of the main reasons why, and I will say this quite honestly, I rushed to have this media conference because I recognize that the public is due some explanation, as inadequate as my explanation at this point might be. So that's the first thing I say. I understand, and I can associate with the sense of outrage that the public must feel. The second thing that I will say is that I also understand, and the outrage has to do with this particular incident, I also understand your ire, your outrage, and that of the public, that people seem to get a bligh, a free pass in our country in many circumstances where they should be held accountable. And the third thing that I will say is, for those of you who wish to believe it, I hope that in the short time I am in office to this point, it's about 8 months, and in the time that I will remain in office, that I can make a difference. I don't subscribe to the lifestyle, not lifestyle is not the word, I don't subscribe to the philosophy that people can commit crimes and walk away. I certainly don't. And I would like to see accountability where accountability is due.
So can we expect a redacted copy? Because I understand that, due process will take its course and it may lead to civil, possibly criminal proceedings might flow from the investigative report. But can the public expect some level of disclosure, whether it is redacted, names withheld, in order to ease the public's mind and possibly restore some level of trust and confidence in the offices that fall within under your ministry?
Redacted disclosure of precisely what, Mr. Achong?
The investigative report.
The investigative report. Let me put it this way. I will certainly report to the country, to the public, on the report and what it recommends when it comes in. The contents of that report, excuse me, how much of it may demand that persons be given an opportunity to comment before the report is made public, I will have to respect that. So I am not about to give any commitment to putting the report into the public domain, redacted or otherwise, but I certainly commit to reporting to the fact that in the shortest possible time, there will be an investigation. I will ask the investigator to report in the shortest possible time, and I will make the fact of his report public as best as I can to the public of Trinidad and Tobago. The citizens of this country don't deserve anything less.
I think we have 2 more questions.
I was just wondering, in terms
Can I take 2 more questions and then return to some other work that I have to do, please?
Yes.
Yes.
So very quickly, what do you say to those the members of the public who are wondering in terms of the system presently, if it's really working in the context of matters involving state civil litigation, and whether or not the structure, because it seems a bit convoluted with different offices and different reporting mechanisms, whether that should be streamlined in a way so that the Attorney General, whoever that person is not left in the dark, as you have said has happened in this particular instance.
Can I answer that by looking at a very recent piece of history, Mr. Joel Brown? I actually took a note to Cabinet, I think it was about 3 weeks or a month ago, in which I asked and Cabinet approved the upgrade and better streamlining of the AG Secretariat to help me better coordinate the activities of the entire Ministry of the Attorney General and Legal Affairs. So that's already approved by the Cabinet to give me greater reach and to call for greater accountability and coordination of the activities of the Ministry of the Attorney General.
My question is unrelated to this. It's just to get an update on the Prime Minister and whether or not he is today.
The Prime Minister was in full flight. We had a National Security Council this morning meeting, and I had to literally beg time off to come to this meeting. He's in good shape. He's in fighting fit shape. I don't know whether he ate. While we were meeting, we were not eating. We were doing the people's work. Thank you very much, Mr. Thank you, ladies and gentlemen.
The winning numbers in the National Lottery online draws for Wednesday, 1st February 2023 at 10:30 a.m. Playway, the number 11, Kobo. Pick 2, the numbers 24 and 19 in that order. Pick 4, the numbers 0,